Good morning. Myself, Dr. Rajinder, Assistant Professor, Department of Laws, Punjab University. I will be speaking on the module of Right of Exploitation under Article 23 and 24 of the Constitution of India. The objective of the module is to discuss in detail the right against exploitation expressly recognized in the Constitution. The learning outcome of this module is that Article 23 and 24 under the Constitution guarantees the fundamental right against exploitation. The right is wider in application as available to every person, citizen or non-citizen. To enforce these articles, Child Labour Prohibition Regulation Act 1986 and Bonded Labour System Abolition Act 1976 was enacted. In Asiad case, the Apex Court widened Article 23 by including the wages paid less than minimum wages will fall within the purview of Article 23 of the Constitution. The module also discusses the case of President Cinema workers where non-revision of wages in 5 years by the appropriate government was held to be violative of Article 23. It also covers the MC Mehta case where the Apex Court laid down the blueprint to tackle the problem of child labour. In this series, the module also discusses the latest judgments of Bachao Andolan for directions which has been issued to rehabilitate the children working in the circuses. While introducing right against exploitation, I would like to highlight that the fundamental right enacted in Part 3 includes basic, inherent human rights which a human possesses. These rights operate as limitation on the powers of the state and impose negative obligations on the state not to intrude on individual liberty. But under Part 3, there are certain fundamental rights which are bestowed by the Constitution which are enforceable against the entire world. They are Article 17, 23 and 24. Article 23 incorporates in the Constitution to prohibit traffic in human beings, begar and other forms of forced labour. While drafting Article 23 of the Constitution, two drafts were proposed regarding the right against exploitation, while Dr. Ambedkar draft simply provided that subjecting a forced labour or involuntary servitude would be an offence. On the other hand, K.M. Munshi draft was more elaborative, containing the provisions for the abolition of all forms of slavery, traffic in human beings and compulsory labour. The provisions relating to the slavery and involuntary servitude in clause 1 were based upon the 13th Amendment of US Constitution. Section 1 of 13th Amendment provides neither slavery nor involuntary servitude except as a punishment for crime whereof of the party shall have been duly convicted shall exist within the United States or any place subject to their jurisdiction. As far as prohibition of recruitment for military services or training concerned, in subclause 2 there was no precedent available. On the other hand, some constitution like Swiss Constitution in Article 18, Para 1, Czechoslovakian Constitution in Article 127, para 1 and Chinese constitution under article 30 contained specific provision imposing compulsory military services on their citizen. The constitution does not specifically define the word begar. In the case of S. Vasudevan and others versus S. D. Mittal, Justice Stamke referred to Molworth to define the word begar, which says that labour or service extracted by the government or a person in power without giving remuneration for it. He further quoted Wilson's glossary for the meaning of the word forced labour, which means one pressed to carry burdens for individuals or to the public under old system. When pressed for public services, no pay was given. The Bombay High Court observed that to bring a case within the mischief under subclause 1 of article 23, it must be established that a person is forced to work against his will and without payment. A custom which was prevalent in Manipur state came to the notice in Kahosan Thangkul versus Simri Shalar case, in which each of the village holders in the village have to offer 1 day free labour to the headman of the village. The appellant in that case denied to tender 1 day's free labour to the headman and challenged the validity of the custom as being in contravention of article 23 subclause 1 of the constitution. The court upheld that the custom is violative of article 23 subclause 1 of the constitution. The landmark case PUDR versus Union of India, popularly known as Asiad Game case, was the result of a public interest litigation which was initiated with the letters addressed to Justice P.N. Bhagwati. The letters were based on an exploration by 3 social scientists alleging the violation of labour laws by the Union of India, Delhi Development Authority and Delhi administration. The prime accusation was that the contractor paid wages to crew bosses who subtracted a commission, then made the payment to the workers which were less than the minimum wages prescribed, that is rupees 9.25 per day. The question arose before the Supreme Court was whether Article 23 can be made applicable to a condition where workers are paid less than minimum wages. While delivering the judgment, the court took into consideration the international instruments, that is ILO Convention 29, European Convention on Human Rights and International Convention on Civil and Political Rights, and observed that the Article 23 prohibits the forced labour in whatever form it is found or existed. The court also relied upon 2 US cases, Bally versus Alabama and Pollock versus Williams, and further laid that Article 23 was anticipated to cover all forms of forced labour, even if the workers or persons have entered the contract voluntarily. The court focused the study on the specific term, that is force in forced labour, and also highlighted the different ways through which force can be used by physical compulsion, hunger, poverty and economic situations can also be the reason. In all these circumstances, a person does not have an option but to accept any employment on wages less than minimum wages. The apex court observed that accepting employment less than minimum wages specified will also fall within the purview of Article 23 of the Constitution. In Sanjit Roy versus State of Rajasthan, the state government undertook a relief work in a drought-hit area manifestly with the aim of providing persons affected with some kind of a work. The wages paid to the persons employed in the relief work were much less than the minimum wages. The court invalidated the provisions of the Rajasthan Famine Relief Work Employees Act 1964, which exempted the application of the Minimum Wages Act 1948 to the employment of famine relief work. In another landmark case, in Bandra Mukti Morcha versus Union of India, the public interest litigation was filed by Bandra Mukti Morcha through a letter to Justice Bhagwati contended the situations of huge numbers of labourers working in inhuman circumstances as bonded labourers in stone quarries of Haryana. It was further contended that it was in gross violation of Bonded Labour System Abolition Act 1976. The court assumed the letter as a writ petition. The court also appointed a commission of 2 lawyers to check out the situation of stone quarries. The commission bring out that the workers were working in inhuman conditions and they were not having clean water to drink, living in improper places without basic amenities. The Haryana government, with a view to avoid rehabilitation requirement for bonded labourers as obligatory under the Bonded Labour System Abolition Act 1976, turned with a new argument that they may fall under forced labour but not bonded labour. The court initially highlighted that the act was made with the objective to give effect to Article 23 of the Constitution, which forbid traffic in human beings, beggars and other similar forms of forced labour. The court observed that it is patently obvious that the bonded labour is a form of a forced labour. The court further highlighted that the situation of the workers are an illiterate persons who will not have a documentary proof to prove the advance taken. And it further laid down that it is unkind to give benefit of above referred social welfare legislation through the cumbersome process of litigation involving process of trial and procedure of recording evidence. Such kind of application process will practically result into non-implementation of this act. Therefore, in such circumstances, whenever the labourer is made to provide forced labour, the court will presume that it is the result of consideration of an advance or other economic consideration received by him. This is a rebuttable presumption but with cogent evidence. In Nirja Chaudhary versus State of MP, the court reasserted the same view, and the court here also insisted not only release but rehabilitation of bonded labour. In this case, the fact that 135 workers were released from bondage in Bandra Mukti Morcha case were not properly rehabilitated, and their plight was highlighted in the present case by Nirja Chaudhary, the civil right correspondent of the Statesman, Delhi. The court squarely placed the responsibility on the state government and directed it to provide rehabilitation assistance to these people within the month. In another case, Government Engineering Colleges versus Srinivasan, the court has observed that Minimum Wages Act is a pre-constitution enactment, and the provision therein shall be read to the provisions of the Constitution, where a person is compelled to force by circumstances like hunger, poverty, to provide labor or service to another for wages which is less than minimum, the case will clearly fall within the scope and ambit of the words forced labor under Article 23 of the Constitution. In another landmark case, in the President Cinema Workers Union affiliated to Bharatiya Mazdoor Sangh versus the Secretary Social Welfare and Labour Department and others, the notification was issued in the month of July 1992 fixing the minimum wages, and thereafter no fresh notification was issued till the present case was filed. The government cannot indefinitely postpone the issuance of revised notification fixing the minimum wages, particularly in the view of the intention of the legislature. This point was highlighted by the judiciary, and along with that there should be a possible review of the minimum rate of wages at such intervals not exceeding 5 years. Wherever for any reasons the wages are not reviewed within the period of 5 years, the same have to be reviewed within the reasonable period. In this case, there was no revision of case for 13 long years. Definitely, the period of 13 years cannot be said to be reasonable period. In view of above, it is clear that the government inaction in this case is violative of Article 23 of the Constitution of India. Another important issue under Article 23 is the prisoner's right to wages. Whenever the payment has to be made equivalent to the service rendered, otherwise it would be a forced labor within the meaning of Article 23. Whenever during the imprisonment the prisoners are made to work in the prison, they must be paid wages at reasonable rate. The wages should not be below minimum wages. In Constituent Assembly debates, the issue was specifically highlighted but later on dropped during the discussion. In the case of prison reforms, enhancement of wages of prisoners, etc., the court has been receiving petitions from prisoners in the various jails of the state, either directly or through the grievance deposit boxes maintained in the jails, on the issue whether the prisoners were entitled to reasonable wages for the amount of labor extracted from them while serving the sentence. The approach to the question of payment of wages is different and differs in the world from state to state. From 1877 to 1913, some local English prisons used to pay gratuity, however small, to the inmates. This practice was totally abolished in 1913, but reintroduced later in response to a fairly large body of public opinion. The wages paid in the United States of America is said to be meager. Wages are paid in the shape of compensation in Belgium and Japan, premium in Sweden, gratuity in China, bonus in Thailand, and reserve in Portugal. But the wages supplied in all these countries are meager and not inadequate, are not in recognition with the right of the prisoner to claim such wages. Hence, to sustain a claim of the prisoner for a reasonable wages which a man outside the prison would obtain by negotiation supplemented by the labor and welfare of the laws of the country, there is no precedent brought to the notice of the court. The consequences of this provision is that if we deny wages to a prisoner, that is minimum wages, in return to his work, it is violative of Article 23 subclause 1 in the Constitution. Consequently, the state could be directed not to deny such reasonable wages to the prisoner from whom the state takes the work in the prison, but they deliberately did not specify the word minimum wages. The same issue was taken up in State of Gujarat versus Honorable High Court of Gujarat, and the question was again mooted whether the prisoners who are under obligation to do labor as a part of their punishment should essentially be paid remuneration for such work at the rates prescribed under minimum wages legislation. All the judgments were considered in appeal. In this case, it was held that it is lawful to employ the prisoners sentenced to rigorous imprisonment to do hard labor, whether he consents to do it or not. It is essential that the detainees should be remunerated reasonable wages for the work done by them. In order to decide the quantum of reasonable wages to the prisoner, the state government shall comprise a wage fixation body. Until the state government takes such decision, on such suggestion, every inmate must be paid for the work done by him at such rate or revised rate as the government fixes, in the light of the observation made by Supreme Court in the judgment. Clause 2 of Article 23 is an exception clause which enables the state to impose compulsory service for public purposes. However, while imposing such compulsory service, the state is prohibited from making any discrimination on the ground of religion, race, caste, class, or any of them. Coming to the next provision, that is Article 24, which specifically deals with prohibition of child labor, and this labor issue of children and provision of compulsory universal primary education has not been taken up in the Constituent Assembly only, but it was advocated long before the independence. In 1906, Gopal Krishan Gokhale, the then President of Indian National Congress, unsuccessfully urged that the British government to establish free compulsory elementary education. The movement continued with the setting up of the Constituent Assembly in 1949. It was resolved that the future Constitution of India would provide for abolishing child labor and ensure compulsory education to children. The reference was made to Article 23, Para 2 of Yugoslavian Constitution in this regard, which prohibits the employment of children in mines, factories and other hazardous jobs. Article 24 provides no child below the age of 14 years shall be employed to work in any factory, mine or engaged in any other hazardous employment. It must be noted that this article does not create an absolute ban to the employment of child labor. In the first place, article applies only to children below the age of 14 years. Secondly, even in case of children below 14 years, this article only prohibits the employment of children in factory, mine or in any other hazardous employment. Judiciary has played a crucial role for the protection of children in People Union Democratic Rights versus Union of India, that is the Asiad case. It was contended that the Employment of Children Act 1938 was not applicable in case of projects in Delhi, since construction industry was not a process specified in the Children Act 1938. The Apex Court held that Article 24 of the Constitution, which even if not followed up by appropriate legislation, must operate, and construction work is included in the hazardous occupation. In labourers working on Salil Hydro project versus State of Jammu Kashmir, the Honorable Apex Court directed that whenever the central government commences a construction project which is likely to last for a substantial phase of time, it should ensure that children of construction workers who are living at or near the project site are given amenities for schooling. The court further lays down that this may be done either by the central government itself or any part thereof to a contractor. Necessary provision to this effect shall be made in the contract with the contractor. In Rajangam Secretary District BD Workers Union versus State of Tamil Nadu, the Supreme Court observed that the tobacco manufacturing was certainly an unsafe occupation for the health of the children. As far as possible, the children in this avocation should be banned. The employment of child labor in this industry should be closed without delay, or it can be dealt in a phased manner which is to be decided by the state government, but the period should not be exceeding 3 years. In MC Mehta versus State of Tamil Nadu and others, a landmark case which laid down a blueprint to tackle the problem of child labor, MC Mehta, a public spirited lawyer, filed a public interest litigation in 1986 against the harrowing practices of employing children in matchworks, fireworks and explosive factories of Shivakasi in Tamil Nadu. The Supreme Court delivered landmark judgment giving the following direction. Firstly, in the fulfillment of the legislative intention behind the enactment, the Child Labour Prohibition and Regulation Act 1986, every offending employer must be asked to pay an amount of Rs 20,000 for every child employed in contravention to the provisions of this Act. As a large number of working children are still engaged in such occupation, asking the respective state governments to assure alternative employment to an adult would restrain the sources of the state. As such, where it is not possible to provide a job to an adult member of the family, the government concerned, as its contribution and grant of Rs 5,000 per child in the Child Labour Rehabilitation cum Welfare Fund. They should be conducted to the type of child labour under the issue, which should be completed within 6 months. In case where alternative employment cannot be made available to the parent, guardian of the concerned child should be paid the income earned as an interest on the corpus of Rs 25,000 for each child every month. The employment given or payment made would cease to be operative if the child is not sent to the school by the parent or the guardian. On discontinuation of the employment of a child, free education should be assured in a suitable institution with a view to make him a better citizen. In another significant judgment on the basis of public interest litigation, Bandra Mukti Morcha versus Union of India, a number of guidelines on the recognition, release, rehabilitation of child labour has been given. These guidelines were given by the court in the background of employment of children in the carpet industries in the state of Uttar Pradesh. In this case, the court issued the following directions to the government of Uttar Pradesh. Firstly, to examine the situation of child employment. Secondly, welfare directions to be issued which result into the total exclusion of child below 14 years of age from any kind of employment. Thirdly, providing facilities for education, health, hygiene, healthy food, etc. In another case of Bachao Andolan versus Union of India and others, the Supreme Court observed that the Delhi Action Plan lays down a detailed procedure for interim care and protection of the recused children to be followed by the Labour Department as prepared by the National Commission with the modification mentioned in the judgment, and it further directed the authorities concerned to immediately implement the same. The Apex Court directed that in the light of infrastructural constraint, the Labour Department Delhi has to commence implementing the Delhi Action Plan by accommodating for the time being about 500 children every month. In another important case, Bachao Andolan versus Union of India, the Apex Court in 2011 has taken up the issue of children working in circuses and instructed the government to prohibit the employment of children in circus business. Until recently, the form of entertainment was exempt from the laws which state has the state no child under the age of 14 can be placed into the labour. However, an amendment has been passed to bring circuses in line with other industries, and as it has been ignored, now the government has been encouraged to impose a complete ban on the same. The court planned to deal with the problem of child exploitation systematically. In this order, the court has limited the directions regarding the children working in the Indian circuses. First and foremost, put into practice the fundamental right of children under Article 21A is very important. The central government prohibiting the employment of children in circuses within 2 months from today. The respondents are aimed to conduct synchronized raids in all circuses to release the children, verify the contraventions of fundamental right of the children, and the children are to be kept in care and protective homes till they achieve the age of 18 years. The respondents are also directed to speak to the parents of the children in case they are ready to take their children back to their homes, and they must be directed to do so after appropriate authentication. The respondents are directed to frame suitable design for rehabilitation of the children which are rescued from the circuses. While concluding my module, I would like to say that bonded labour contracts are not purely economic contracts which were voluntarily entered by the employees due to economic necessities. Once the employees enter into these relationships, they are characterized by multiple asymmetries and high exit cost, which are not a part of a contract as understood by the employee at the outset. Article 23 of the Constitution is though an economic right applicable against the whole world, but its interpretation has been widened by the Supreme Court with the changing time and need. But still, even after giving the status of fundamental right from the inception only, we are unable to curb the problem. The problem of child labour is also a very strong issue in India. The state is not exonerated from its duty by enacting legislation which is not sufficient to achieve the desired goal. To tackle this kind of a social problems, involvement of society at large is needed. All sections of society, government, elected representatives, trade unions, employers, legal and judicial fraternity, NGOs, academicians, media can play a positive role in sensitizing the society towards the hazards of child labour and encourage the reporting of these violations. I would like to quote Dr. Dorothy while concluding my module when she said, we have to work to save our children and do it with full respect for the fact that if we do not, no one else is going to do. Thank you.